Hey there, I'm the MadCatster. Am I glad to see you here? Well, we haven't talked about the TikTok psychic in a while. I know you guys have been wanting an update in that case, so I'm going to give you an update. You know me, I've got the deets and all the receipts, so buckle up and let's go. So, hey, you guys, I am here with Sybil the Enforcer, and I know you guys haven't seen her in a few months because she's slowing down now. She's getting kind of old, and she, for a while, has been sleeping upstairs in the bed, upstairs in my bedroom. And recently, she's now decided, now that it's winter, I guess, that she wants to come sleep back down here in my library. And so I grabbed her out of her bed, which she's purring, so I guess she's not too upset with me. But just so you know, she is well. She's just old. I want to apologize because I know I haven't been terribly consistent. I've only been posting about once a month the last few months, but I am working now to get back to a regular video schedule. So you should hear from me at least once a week, but I'm hoping twice a week. I'd like to do 8 videos a month, and now that it's winter and Sybil's down here, hopefully she'll be joining me for every video. So today I'm going to give you an update on the TikTok psychic case that she has going with the University of Idaho professor, whom she wrongfully and outrageously accused of being responsible for the deaths of some students from the University of Idaho. For those of you who are familiar with this matter, when we get into this ruling, it'll give us a little bit of a brief overview and recap of the case. And so it should bring everybody up to speed, even if you haven't been following this story. Sybil, I don't know if you can hear her. She's purring away. So she is happy. She's happy to be here. She's happy to be sitting with me making a video because it's been quite a while. But anyway, so let's get into that. I've got some people to thank for the Amazon wish list at the end of the video. So just to refresh your recollection of where we left this matter, the TikTok psychic had summary judgment against her in the issue of whether or not she was liable for the defamation. The court found that indeed Ashley Gillard was liable for defamation. All that remains now is to determine the damages, and for that there will be a trial, which I looked, they still haven't set the date. So it has to be coming. I mean, this has been going on now for just over 2 years. So for those of you who see courtroom trials on TV, this is at the actual pace of how the judicial system works. Okay, it's been over 2 years and we still don't have a trial date. But when last we visited this, Ashley Gillard had asked that the magistrate judge who had been appointed to oversee this case by the sitting judge, and we've discussed in my previous videos how, that's fairly normal when there's a big load of cases, and it's more like I see it a lot in terms of like small claims where a judge doesn't actually do the small claims trial. It's usually a magistrate who does the small claims trials, but in this case it was a federal district court magistrate who had been, to this point, overseeing the proceedings. Both parties had signed a consent saying that they were okay with the magistrate handling the proceedings in this matter, and that's why the magistrate continued to hear and rule on various motions, etc. Well, Ashley Gillard then said, well, I'm not happy with how this has turned out. And what she did was went back to the court with a motion asking them to allow her to revoke her consent to have the magistrate preside over these proceedings and basically have a do-over because she didn't like the outcome. Well, you can't just say, I don't like it, so let's do it over. Yet Ashley Gillard still asked the court to allow her to revoke her consent and send this back to the regular sitting district court judge. So let's get into what the court had to say about that request. So here it is, the memorandum decision in order, and it's Rebecca Schofield versus Ashley Gillard, as you know, and it's the United States District Court for the District of Idaho. So here is what the court had to say. They say that pending before the court is defendant Ashley Gillard's motion for reassignment from the magistrate judge back to a regular sitting district court judge in federal court. Having reviewed the record and the party submissions, because the team for Rebecca Schofield, of course, filed a response to this motion. Ashley Gillard filed saying, we totally disagree with that. She's not entitled to this, etc. And the court says the court finds that the facts and legal argument are adequately presented and that oral argument would not significantly aid its decision-making process, and it decides the motions on the parties' briefing. So the court doesn't think that there's going to be anything to be gained by pulling the parties into court, having them argue for Ashley Gillard her motion, and having Rebecca Schofield's legal team argue her response and her, obviously, objection to that. And the court's saying that there's nothing to be gained by that, so we're just going to take the pleadings that the parties filed. It's what we call deciding it on the papers. The court's just going to use the briefings, and they're going to make a decision just based on what the parties had to say in the papers. And the court says, for the reasons stated below, the court denies Ashley Gillard's motion to reassign her case to the district court. The background, and this is just a brief background of how we got here, and for those of you who may not be totally familiar with this case, background, this case arises out of the tragic deaths of 4 University of Idaho students in Moscow, Idaho. Following the deaths, Gillard posted videos on social media alleging, based on her clairvoyant abilities, allegedly, that plaintiff Rebecca Schofield had a romantic relationship with one of the students and was involved in the deaths. After Gillard refused to cease and desist posting information about Schofield, Schofield filed this defamation case against Gillard. And you can go back, if you're not totally familiar, I do deep dives on the different steps along the way of this case. You can go back and take a look at my videos about the TikTok psychic. The clerk in the court randomly assigned this case to a magistrate judge. After Schofield appeared, the parties were notified, in accordance with the District of Idaho General Order, that a magistrate judge had been assigned to conduct all proceedings on the case, including any trial and the entry of a final judgment, if both parties consented. And that's what's important here. This wasn't an arbitrary decision on the court's part. Both parties had to consent to this, because a magistrate is not a judge, a regular judge. And so in order to avoid any issues, the court asked the parties to consent to the magistrate being put in place of the district court judge. And it says, thereafter, both parties filed written consents to the magistrate judge conducting all proceedings. And we talked about that in my last video on this. As the case proceeded, the magistrate judge ruled on numerous matters. For example, because Gillard had initially failed to timely respond to Schofield's complaint, the clerk of the court entered a default judgment against Gillard. After Gillard responded and Schofield moved for a default judgment, the magistrate judge granted Gillard's motion to set aside the entry of default and gave her an additional 21 days to respond to Schofield's complaint. Thereafter, the magistrate judge ruled on several other motions, including Schofield's motions to dismiss Gillard's counterclaims, to quash summons to Schofield's counsel, which was absurd, and we've talked about this. You can't subpoena the other side's attorney who's representing him in this matter, to quash a subpoena, and for sanctions against Gillard. Now, as we've talked about, the court's been very lenient, and they tend to be very lenient with parties who represent themselves. Again, foolishly, because Ashley Gillard should have an attorney in a case this significant, but she chose not to. So the court does give her a lot of leeway because she's self-represented, and they remove the default, even though, in my opinion, from the facts and everything I read and from the videos we saw of her, she was aware of this case, and she basically said she was going to wipe her butt with the lawsuit in one of her videos. And however, the court still gave her the benefit of the doubt and allowed the default to be removed and the case to move forward. Eventually, Schofield moved for partial summary judgment and for leave to file a claim for punitive damages. After hearing oral argument, the magistrate judge found Gillard had defamed Schofield and granted Schofield's motion for partial summary judgment. Further, the magistrate judge ruled Schofield had established reasonable likelihood of proving, by clear and convincing evidence, that Gillard's conduct supported a punitive damages award. In response to the magistrate judge's decision, Gillard filed a request for reassignment to a U.S. district judge, which is a form document posted on the court's website. This document requests that the reference to the magistrate judge be vacated and that the case be reassigned to a district judge under the federal rules. At the same time, Gillard also filed a motion to alter or amend judgment because, of course, she wasn't happy with the fact that they found her liable for the defamation, and so she wanted that also to be reversed. Specifically, Gillard requested that the court reverse the magistrate judge's rulings granting partial summary judgment for Schofield and allowing Schofield to assert a punitive damages claim. The magistrate judge referred Gillard's request for a reassignment to a district judge and, to the extent necessary, her Rule 59E motion. In support, the magistrate judge relied on Ninth Circuit authority that only a district judge may rule on a request for a reassignment. And so that's why this was sent over to the district court judge to review and to make a decision, and this is their decision that we're talking about right now. Only a district court judge may rule on a motion to withdraw consent to the jurisdiction of a magistrate judge. Thereafter, the clerk of court randomly assigned the pending motion to this court. As Gillard acknowledges, both parties voluntarily consented to the magistrate judge proceeding in this case. Conceding, all parties consented to the magistrate jurisdiction. And then there were the executed consent forms, which I showed you guys in my last video. Shortly after the magistrate judge issued its decision on summary judgment and punitive damages, however, Gillard filed the form request document, Request for Reassignment of a United States District Judge, which she obtained from the court's website. That form, however, is not intended for the purpose of reassigning a district judge to a case after the parties have already consented. And I believe we discussed that in the last video I did on this. Rather, the website expressly states that a reassignment will occur after the clerk of court receives the request if the parties have not already consented, and that once you have consented to a magistrate judge jurisdiction, you cannot later request reassignment to a district judge using the form. Nonetheless, the court construes Gillard, so again, because she's self-represented, they're going to give her a little bit of leeway. They're not going to, of course, give her what she wants just because she's self-represented, but they're going to give her a little bit of leeway. They say, nonetheless, the court construes Gillard's reliance on the form as a motion to withdraw her consent to the magistrate judge's jurisdiction. And that's how I took it too, because that's basically what it was. It was a motion to withdraw her consent. Because Gillard apparently misunderstood the form's purpose, she did not file a brief in support of her request to withdraw her consent. To the extent she complains about the magistrate judge, those arguments are either made for the first time on reply or in her brief in support of her Rule 59E motion. In accordance with the federal court's practice of liberally construing pro se filings by people who are self-represented, as we talked about, the court considers those arguments for purposes of resolving Gillard's motion to withdraw her consent. Cites to a case where they say a document filed pro se is to be liberally construed. So basically, they give latitude to people who are self-represented in that they're not going to completely understand necessarily what all the rules and what all the procedures are. A party does not have an absolute right to withdraw her consent to proceed before a magistrate judge. However, the law provides that the court may, for good cause shown on its own motion, or under extraordinary circumstances shown by any party, vacate a reference of a civil matter to a magistrate judge. Similarly, Rule 73 provides that on its own for good cause, or when a party shows extraordinary circumstances, the district judge may vacate a referral to a magistrate judge under this rule. The Ninth Circuit has noted the extraordinary circumstances standard is a high bar which is difficult to satisfy and intended to prevent gamesmanship. Neither mere dissatisfaction with the magistrate judge's decision nor unadorned accusations that such decisions reflect judicial bias will suffice. The case law is clear that dissatisfaction with the magistrate judge's rulings, absent other evidence, is not sufficient to vacate consent. So basically, the court is saying you can't just say, oh, I don't like what happened, therefore I'm withdrawing my consent, once you've already given it. And there was no evidence that anything extraordinary had happened or any evidence to bolster her argument. So basically, it was just a case of her saying, I don't like what happened, therefore I'm revoking my consent. Let's do it over in front of a regular judge. You can't do that. No extraordinary circumstances were shown here, but rather the plaintiff simply was displeased with the magistrate's rulings on the motions to dismiss. Further, an appeal, not a reassignment, is the appropriate avenue to address any alleged erroneous rulings. Gillard's primary challenge to the magistrate judge proceeding in this case appears to be her concern that his impartiality is impaired and that he is biased against her. In support of this challenge, Gillard contends that due to the magistrate judge's personal lack of belief in Gillard's spiritual practices, i.e., claircognizance, intuition, tarot card, and oracle card reading, he acted in a way that impeded upon Gillard's right to an impartial tribunal. The magistrate judge's lack of impartiality and inherent bias regarding Gillard's spiritual practices and its plausibility impeded upon his ability to judge the case without bias, and that was what her argument was. After reviewing the entire record in this case, this court is unable to locate any support for Gillard's accusation that the magistrate judge was biased against her. Rather, his rulings are based on the record, rely on applicable and persuasive authorities, and are supported by sound legal reasoning. Further, the magistrate judge's interactions with Gillard during the summary judgment oral argument were both polite and patient. Indeed, he even stated that there may be valid uses to a spiritual intuition and tarot card readings, but that to avoid summary judgment, Gillard needed admissible evidence to establish a genuine issue of material fact. And you can't just say, I had an intuition, judge, that's my evidence. That's not how our courts of law work. You have to actually present tangible evidence that the court can look at to make a decision about who's right or who's wrong. This reminds me a lot of the Salem witch trials, if you're familiar with the Salem witch trials of 1692, where they admitted what was called spectral evidence, which was something that was basically unheard of in terms of the law. And they allowed these like visions and these like supernatural quote unquote experiences of these quote unquote victims to serve as evidence, when it was ridiculous because it wasn't actual evidence. It was just somebody saying, oh, this person is doing this to me and I'm telling you this because it's happening, and it's spectral evidence because it's supernatural, and therefore the court should just accept that as fact. And outrageously, the court in Salem accepted that, and a lot of innocent people were convicted and lost their lives due to this nonsense. And so basically the court's saying, you can't just say, oh, I had an intuition or my tarot card told me this. You need to have actual evidence to support your argument. In an attempt to persuade this court that the magistrate judge was biased against her, Gillard misrepresents the record. For example, she asserts the magistrate judge's inability to be impartial is exemplified by his continuously mocking and ill statements about her spiritual beliefs and practices. Gillard, however, fails to cite any support in the record for this accusation, and as stated above, the court has been unable to locate any indication in the record that the magistrate judge exhibited any bias. And I agree. And in fact, Rebecca Schofield's attorneys requested a transcript of the proceedings so that they could also review it and see, did we miss something? Are we oblivious to something that happened in court right in front of us? And no, there was no evidence that there was any bias at all. She just didn't like that the court wouldn't just accept what she had to say. Further, Gillard states that the magistrate judge made specific statements demeaning her spiritual beliefs and practices, calling them baseless, delusional, fanciful, lacking common sense, and implausible. To the extent the magistrate judge used these terms, however, he was directly quoting Supreme Court authority on the Rule 12b-6 standard for dismissal of frivolous claims. So the judge wasn't saying these things. The judge was citing to precedent, to Supreme Court decision that said these things about this type of quote-unquote evidence. The magistrate judge was not characterizing and did not characterize Gillard's beliefs and practices using this language as Gillard misrepresents. Moreover, as Schofield notes, the magistrate judge has not ruled against Gillard in every instance. Rather, he has frequently ruled in her favor. For example, he set aside the clerk of the court's default entry against her despite Schofield's objection and denied Schofield's motion for a default judgment. Further, he denied Schofield's request for attorney's fees, denied a motion to sanction Gillard, and sua sponte granted, sua sponte means the court does it on its own, without any request from one of the parties, and sua sponte granted Gillard additional time to respond to Schofield's request for admission. These rulings contradict Gillard's assertion that the magistrate judge was biased against her. And I wholeheartedly agree. Like we talked about, the court has given her plenty of leeway in order to make sure that this was a fair proceeding. Gillard's other arguments in support of withdrawing her consent are that the magistrate judge's rulings are erroneous and that reassignment is necessary to prevent an unnecessary appeal to the Ninth Circuit. Erroneous rulings, however, do not constitute extraordinary circumstances warranting a reassignment. If Gillard disagrees with the magistrate judge's rulings, the proper method to challenge them is by appealing. In this case, Gillard must file that appeal with the Ninth Circuit once the judgment is final. Upon entry of judgment in any case in which the parties consented to the magistrate judge, an aggrieved party may appeal directly to the appropriate United States Court of Appeals from the judgment of the magistrate judge in the same manner as any appeal from any other judgment of the district court. So in other words, after the trial and the damages is held and a final judgment is entered, then Ashley Gillard is free to file an appeal. I don't think she's going to win an appeal because I think the evidence is overwhelmingly against her, and we've talked about this before. A, she should have had a lawyer represent her, and B, she should have known when to quit, and she was given that opportunity by the plaintiff, the professor's counsel, and the professor before this even got started in the court, and she mocked and basically gave a middle finger to the professor and her legal team, and so basically it's her own fault that she's in this mess. In summary, Gillard has failed to establish any extraordinary circumstance justifying reassignment of this case to a district court. The record does not show that the magistrate judge was biased in any manner towards Gillard. Instead, the timing of Gillard's motion to withdraw her consent and her Rule 59E motion filed shortly after the magistrate judge granted Schofield partial summary judgment and leave to assert a punitive damages claim indicates Gillard's real motivation is to avoid the magistrate judge's rulings, of course. She just doesn't like the decisions. So this is her way of trying to undo it. The court does not condone Gillard's unsupported disparagement of the magistrate judge to obtain a new judge. Because the court denies Gillard's motion to withdraw her consent to the magistrate judge, it does not address her Rule 59E motion, which remains pending before the magistrate judge. And then so the order is, Gillard's motion for reassignment to a district judge is denied. Now, that's not surprising. We discussed this in the last video I did about this, but I mean, this is clearly where this was going to end up. She didn't have any good grounds to ask to revoke her consent to the magistrate judge. The magistrate judge's rulings will continue to be in effect. We now will move towards a trial. And again, the trial will only be about damages and whether and how much the professor, Ms. Schofield, is entitled to damages against Ashley Gillard now that the court has decided that Ashley Gillard is in fact liable for defaming the professor. Unsurprisingly, if you've been following this case and the outrageous things that Ashley Gillard has said about this plaintiff, who I feel so much sympathy for because she's just been unnecessarily dragged into this tragic situation and had her life disrupted and unnecessary publicity thrown on her because of one person's actions, and terribly negligent and terribly inflammatory statements, in my opinion. Now we just wait and see when a trial date is set. Let me know what you guys think. Tell me down below in the comments. If you're surprised, I'm guessing none of you are surprised that this is where we've ended up. I will keep you posted as soon as the trial date comes up. I'll let you guys know like what's going on, or if she files anything else in this. I don't expect the professor is going to file anything unless Ashley Gillard decides to file something else. And again, she can't appeal until the final judgment comes down, which won't be until the trial on damages is concluded. I'm breathlessly waiting for the trial date to get set and to see whether there's going to be some sort of electronic transmission of the trial or how it's going to be conducted, to see if there's any way we can sort of follow along with it. But I'll let you know. I'm certainly not going to fly out to Idaho just to cover this. I don't think it's worth making a whole trip out there for this. But there you go. That's where we stand. Let me know down in the comments what you think of this whole matter. Let me know if you've got any suggestions for any pending legal matters you want to hear about. I'm going to give you some updates on some of the other cases we had been covering. I had been holding off on giving you an update on the Illuminati situation out of respect for Oz, because he was going to make a video just before the holidays where he was going to address his response and his counterclaims against her. He has decided not to do that because they are, I guess, now trying once again to come up with maybe some kind of a settlement. But you guys keep asking me, so I am going to give you an update on what's going on. I'm going to be as respectful as possible to Oz because I do like and respect him a lot. So there's a part of what I'm going to talk about. I will sort of be skirting around some of the details because they are very sensitive. That's probably going to be my next one to post for you guys, and then I'll give you updates on the other cases. Look out for those things. I've got somebody to thank for a holiday gift to the cats, and thank you for those people who did send stuff for the cats. But I want to thank Monica. So Monica sent us a nice big bag of the Rachel Ray Nutrish dry cat food. Thank you so much. Cat food's like our biggest expense next to cat litter. So those of you who have sent us food, thank you so much. We really appreciate it. But she also sent us a window seat. Thank you so much. I actually put it up. My cat Sophie liked to sit in the window at the bottom of the stairs, and that one had seen better days. So I took it down and I put the new one up, and she's just as happy as can be. And she lays there all day from the time we get up out of bed, because my cats are so funny. I've told you this before, but my cats will sleep, the ones that sleep in the bed will sleep all night. And even if I get up like to use the potty in the middle of the night, the cats will stay in bed. They don't get up. Until I get up in the morning and say, who wants to eat? They continue to sleep. But once I'm up and I say, who wants to eat? Then they know it's time to get up. They all get up and we eat. But Sophie, after she eats, goes and sits on the bed in the window, and she stays there all day basically. And then at night when it's time for bed is when she finally gets up and comes upstairs and gets into bed with me and the other cats. So thank you very much, Monica. I'm sorry that I didn't have a video before the end of the holidays to say thank you, but thank you so much. Thank you, everyone. Thank you to our Patreon patrons, as always. Those of you who stuck with us. I'm going to be posting some short videos I had made when I was out in California and LA doing the story about Thelma Todd. I did go to the Getty Villa. It survived, thankfully, the fire in Pacific Palisades. That is basically, it's a recreated Roman country villa. It's absolutely beautiful. The setting is stunning, overlooking the Pacific Ocean, and they've got it all landscaped and everything just like what a Roman villa would have looked like. And it houses a really incredible collection of Greek and Roman and other artifacts from the ancient world. And I made some videos while I was out there visiting there. And actually, that's where, not this hat, but the lighter colored one I usually wear, that's actually where I bought it, is at the Getty Villa. That's where I got that. But I'll post those for the Patreon patrons to say thank you. And I'm still going to make, I've been meaning to make short videos about each of the cats. I'm going to do that. I know I've said it before, but I will do that for you guys. They're just going to be short, like giving you the brief story of each of the cats. I used to, at the beginning of my older videos, I would have cats in the videos as there usually are, and I would sort of give you their background. Well, I'm going to do that in a series of videos. So be on the lookout for that content coming over to the Patreon patrons page. So that is to thank you guys who have stuck with us, the Patreon patrons who are so loyal. Also, thank you so much to all of our channel members. You guys, your monthly support helps to... My cat Jill, he wants treats. So, because we do treats before bed and it's almost bedtime, he wants treats. So he's being very vocal right now, my three-legged cat. So that's, if you could hear him, that's him in the background. But so there will be some content for you guys that's going to be on the Patreon page, and I'll begin uploading those this week. So look out for those. So thank you guys again, the channel members, Patreon patrons. If you guys want to join the support, the links are down below. Thank you so much to everyone who has been with us on this journey. We're now going on, God, I want to say it's going to be, is it going to be 4 years in 6 months? It'll be 4 years that we've been doing this. And in spite of the last few months where it's kind of slowed down, I am going to pick the pace up again starting now. So be on the lookout for the content, the videos I just talked about in terms of the updates. Those are coming very soon. One on Illuminati will be at the end of this week. Look for that over the weekend. You guys, in the interim, take care of yourselves, love one another, and I will see you in the next one.
Pretty please. Subscribe, like, and hit the bell. I get a treat for every new sub. Thank you.